Thanks, Tim. Apologies that you had to hear me speak that many times. That's really tragic. Thanks to Tim, Melinda, Mark, and others for organizing tonight's meeting and inviting me to speak with you folks. I hope we can get through it. See, the clouds are darkening without a destructive thunderstorm. I was up in Conestoga a couple of weeks ago at Fire Hall, and the storm blew in and the fire alarms went off and the lights were flickering off and on, and so I hope that it's not on the calendar, so apologies if that comes. My name is Chad Nicholson. I'm with the Community Environmental Legal Defense Fund. We are a nonprofit public interest law firm based in Mercersburg, Pennsylvania, in Franklin County, South Central. A couple of requisite disclaimers since I do work for a law firm. The first is that I'm not a lawyer. I get accused of that quite frequently, and I take real offense. No offense to any lawyers in the room. But just to say that anything that I say tonight is not to be taken as legal advice. I work in this area of law quite frequently, but if there are any questions that you have that I can't answer, I will talk with our attorneys on staff and get back with you. The second thing is that we are a nonprofit public interest law firm, which means that we are not an advocacy organization. So I'm not here tonight to tell you folks to do something or not to do something. I'm going to outline what we have learned as an organization over the past 20 years of working in Pennsylvania, and what communities are now doing to resist large-scale industrial projects like pipelines. And they're using some pretty unconventional approaches that they have developed with us over the years. So I want to get through the presentation relatively quickly so we can get to questions and answers. That should be a bit more productive. But I want to talk a little bit about our organizational history, because the work that we do right now, which is to work with communities to pass what are called rights-based ordinances, is very different than where we started back in 1995. So I want to take a few minutes to outline the story, and then we will get into what communities are doing to stop things like pipelines. We opened in 1995. Our executive director, Thomas Lindsay, who's also our lead attorney, tells a story that he came out of law school. He went to law school in Harrisburg, and he went to law school to be an environmental attorney, essentially to work with communities to resist large-scale harms that were being inflicted upon them in Pennsylvania. And as he tells the story, attorneys that want to do environmental law are told that we have the best environmental laws in the world in this country. Our environmental laws are so good, in fact, that we actually export them to other countries for them to model their own environmental legislation on. So, as he came out of law school and he took a look at Pennsylvania communities, mostly rural Pennsylvania communities, and he saw many different kinds of harms being inflicted upon them, he scratched his head and thought to himself and said, well, if our environmental laws are so great, and yet all of these communities are getting a variety of harms, why is that? The theory at that point was one of two things. Either there are not enough lawyers, or if there are enough lawyers, the communities who most need them don't have the resources they need to hire the lawyers to actually enforce the environmental laws on the books. So that was the theory. Either there's not enough lawyers, or the communities that need the lawyers don't have the money or resources they need to hire them. So the Legal Defense Fund was open to try to plug those two gaps. We opened to provide free legal resources to mostly rural communities across Pennsylvania facing industrial threats to their health and safety. That was what we opened to do. So what did that look like? Well, when you hang out your shingle and you offer free legal resources, your phone starts ringing quite quickly. Within a couple of years, we were representing over 300 municipal governments and community groups across Pennsylvania, facing a variety of harms. The two major ones in the mid to late 90s in Pennsylvania were things like factory farms, so 80, 90,000 head hog factory farms that were being sited in the middle of communities, brought with them a host of activities that the communities didn't want: air pollution problems, trucks coming through, water pollution, all kinds of things. The other big one was the spreading of municipal sewage sludge on farmland. If folks aren't familiar with what sewage sludge is, it's basically anything that goes through a municipal wastewater treatment plant in Philly or New Jersey or New York, wherever it may be. The liquids are separated out into solids. The solids is packaged up into something called sludge cake. Hopefully it's after dinner for most folks. Sludge cake can contain up to 300,000 toxic contaminants because what goes through the wastewater treatment plants can come from hospitals, it can come from industry upstream, it can basically anything you flush down a drain in your house, pharmaceuticals, all these various things. It can contain up to 300,000 toxic contaminants. The EPA tests for a grand total of 11 of those toxic contaminants, EPA being the Federal Environmental Protection Agency. And if those 11 toxic contaminants are not present in the cake, then it is labeled legal for use as fertilizer on farmland. So farmers can be given the sludge for free to spread on their farmland. A lot of folks have concerns about the rest of those 299,989 contaminants. There's been folks in Pennsylvania and New Hampshire that have died from exposure to it. So those were the two big issues that communities were calling us about in the mid to late 90s. So we got these factory farms coming in, we got the sewage sludge coming in. We don't want it for obvious reasons. There are a variety of harms associated with these activities. So they would call us up. The phone call was always the same. There was a very energetic and sometimes hairy person on the other end of the line that said, this corporation wants to come in, they want to spread sewage sludge, they want to put the factory farm in, they've been issued a permit, we don't want it, we think it's going to harm our community, what can you do? And we say, we can help you. We're going to come in and work with your community to fight this activity. What help from our perspective looked like at that point was to work with the community to appeal the permit that had been issued to the corporation to engage in the activity. So all these corporations are issued permits by regulatory agencies. So when it comes to the pipeline, FERC is the relevant regulatory agency. Usually with factory farm and sludge in Pennsylvania, it's the DEP, the Department of Environmental Protection, or as most communities that I work with call it, the Department of Everything Permitted. These regulatory agencies issue permits that legalize the activity to go into the community. So naturally, from our perspective, we looked at the situation and said, if the permit has been issued, then what needs to be fought is the permit, because if the permit is taken away, then the activity cannot proceed. So we would fight the permit with the community. That was our job. That's still what most major environmental organizations and law firms still do today, is they try to fight or appeal permits. So what that meant, and I don't know if folks have ever seen permits that have been issued for these things, but you better have a strong person with you when you're carrying them out of the DEP office because they're huge. It meant we had to identify flaws or deficiencies that were contained within that permit. So we were looking for things that were wrong with the permit. Like they put up the wrong bond amount, or their weapons study was 10 years out of date, or the road study didn't take into account certain trucks that were now on the road. All these different things, wrong person signed on this line, whatever it may be. Our job was to identify flaws and deficiencies within that permit. We would then take the permit in front of the judge, community group behind us, and we would argue and say, Your Honor, this permit is deficient. There's all these things that are wrong with it. All these different things that are required by the permit application that are deficient. These things are wrong with it, so the permit must be tossed. By and large, the vast majority of the time, the judge would actually agree with us. He would say, you know what, you're absolutely right. The permit application does require all of these things. You have to have the weapons study, it's got to be up to date, and the traffic study's out of date, and the wrong person did sign on this line, and their bond amount has to be higher, and all these things. So he would say, you guys are right. The permit is going to be tossed out. No permit, no factory farm, no sewage sludge. Great news. We would go back to the community, sit around kitchen tables, have some beers and some snacks, and we would celebrate. And the community group would say things like, the system works. We identified a problem, we got together in our community, we raised money, we held bake sales, we educated each other, we became experts on all these things. We now know all the toxic contaminants that are contained within sludge. And then we got a law firm involved, and they were able and they were competent, and they came in and they worked with us to identify the flaws in the permit. We took it before the judge, and the judge was just. He actually did take a look at what our concerns were with the permit. He listened, and he made a just decision that was in line with our values as a community. The permit is tossed. We are not going to get the activity that we do not want. Great news. The system works. Except what would happen 30 days, 60 days, 6 months later. The corporation would resubmit the permit application, and this time they would have filled in all of the things that we identified as deficient. They would actually thank us for doing their work for them, for helping them to build better permits. That's essentially what our job became. Still what a lot of major environmental groups do. Actually helping corporations to build better permits. That's what we were doing. Identifying the flaws, pointing them out for them, and they would come back, resubmit the permit application, and would have filled in all the things that we identified as wrong. So, after the corporation would resubmit the permit application, the community group would be on the phone again with us. And they would say, hey, guess what? I know it's 90 days later, but we still don't want the factory farm, even though it's 3 months later. We still don't want the sludge. Go figure. But the corporation has come back with a new permit application. So you guys are the experts at the Legal Defense Fund. We need you to come back in to do whatever it was that you did the first time and get that permit tossed again. Do whatever it is you did. You guys know what you're doing. Come in and do it again. To which we found ourselves having to explain to them that we had no other levers left to pull at that point. Because the legal language is administratively complete. If the permit application is administratively complete, it shall issue. It has to issue as a matter of right to that corporation. It's administrative law. The permit shall issue as a matter of right. If all the I's are dotted, all the T's are crossed, all the things that are required by the permit application are there, the permit has to issue. There's not actually discretionary authority on the part of the regulatory agency as to whether or not they get to issue it. The permit shall issue. The bitter irony in all of this was we were getting all kinds of accolades as an environmental law firm. We had a win-loss record of something like 180 wins to 9 losses in court in all these permit appeal battles that we had done. We actually got invited to the White House as one of the best environmental law firms in the country. But if you looked at the communities that we were representing, they eventually ended up getting the harm that they did not want and that they tried to fight. Because when the corporation would resubmit the permit application, there was no other legal levers or tools that we had to pull in order to try to stop it. It shall issue, the permit did issue, and the activity would cite within the community. The best we were able to do through the permitting process at that point was try to delay it, or try to maybe get better setbacks, or try to restrict the number of trucks coming through. It had everything to do with trying to limit or regulate the harm, and nothing to do with actually being able to democratically decide as a community that they wanted to say no. It assumed the harm was going to take place, and our best options through the permitting process were to try to get the best deal that we could for the community so they would get harmed a little bit less. Had nothing to do with democracy, had nothing to do with decision making. After a couple of years of this, it was like Groundhog's Day. I don't know if folks have seen that movie. It was like reliving this terrible day over and over and over again through hundreds of these permit appeal battles with these communities and taking it as far as we could, but in the end, watching them get the thing it was they didn't want. To which, at some point, this was in the late 90s, communities in South Central Pennsylvania had said to us, why? Why can't we say no? We thought we lived in a democracy. These township supervisors, rural South Central Pennsylvania, would pull out copies of the Pennsylvania Constitution. They would point to it and say, look right here, Article 1, Section 2, all power is inherent in the people. So why, if the power is inherent in us, don't we have the authority to actually say no to something that is going to harm our community's health and safety? We thought we had consent of the governed. We thought we had a democracy. So why is it that 7 people on a corporate board of directors in Texas or Oklahoma or Arkansas have more say over what goes on in regards to agriculture in our community? Why is that? We're asking ourselves the same question. And that began our evolution as an organization, where we delved into the history books. It was about a 5-year painful evolutionary process where we went back to the country's founding and to English common law, where we got our legal system from. We went all the way back to the Magna Carta. We do these things called democracy schools. They're about a day and a half long. We actually trace the legal and the political history of this country, trying to answer that question of why. Why is it that our communities don't seem to have the tools they need to actually say no to things that are harmful, that are facing them? Why is it? Took us a couple of years to come up with the answer, and I'm going to diagram it very quickly. I could spend about 3 hours on this diagram. Nobody wants that, so I'm going to run through it very quickly. But if there are questions at the end of it, please feel free to raise your hand. But we call this the box of allowable remedies. That's what we call it at the office. Because there's a very tightly confined box that you folks find yourselves in your communities when you try to make decisions on issues that are important to you. And you didn't create the box that you're currently living within. It was created by somebody else who doesn't have your interests at heart. It may sound like a conspiracy. I thought it was the first time I heard this stuff. But I've seen it play out over and over and over again in communities that we work with, not just in Pennsylvania, but across the country. So very quickly, this is the box of allowable remedies. And there's a bunch of different legal doctrines that bear down on you in your community to prevent you from governing on important issues. So this is where you folks are, right here inside the box in your community, in that dot. A bunch of different legal doctrines. We're going to just run through them quickly. The first one is something called state or federal preemption. This is where state or federal levels of government can pass laws that actually preempt us in our communities from having a say on certain issues. So I'm sure folks have heard it from Williams or even from your own supervisors, from your state reps, whoever it may be, that this is a federal issue. The pipeline matter is a federal issue. It's going to be decided by FERC. It's not a matter of local control. Sorry, it's a federal issue because the federal government has passed preemptive law that preempts your community from having a say over issues like pipelines. We did a preemptive history of Pennsylvania in our organization a couple years ago. It ended up being about 20 pages long, where we looked at all the times over the last 100 years that the Pennsylvania legislature has passed preemptive laws to remove authority from our communities on important issues facing them. So the state has passed preemptive laws that preempt you from making decisions on things like factory farms, sewage sludge, water withdrawals, toxic waste, tire incinerators, agriculture, mining, forestry, energy infrastructure projects. It goes on and on and on. The point being that the very fundamentals, the basics we need to live, things like food and water and energy, somebody else is making those decisions for us outside of our communities, and we have actually been preempted by state and federal laws from even being given the authority to deal with them in our communities. We've been preempted from that. A lot of folks say, well, why is that? How can that happen? Well, there's a legal doctrine called Dillon's Rule, which was invented, ironically, by a railroad lawyer in the mid-1800s. He was upset that communities were getting in the way of railroad expansion westward in the mid-1800s, this guy John Forrest Dillon. So he came up with this idea. He said, well, what we need is a legal doctrine that defines the relationship between the state and the municipalities is that of a parent to a child. Parent, state, municipal, child. That's still the law in all 50 states today, and what that means is that you are assumed in your communities not to have any authority or power unless the state explicitly gives that to you. And it also means that the state can remove that authority from you anytime that they want by passing things like preemptive laws. Folks might say, well, we've got zoning, right? Why can't we zone the problem? Why can't we zone the factory farm, the sewage sludge, or even the pipeline? A couple things are wrong with zoning from our perspective. We talk about zoning as defining your terms of surrender because it's not allowing you to say no to the project. It's deciding which part of your community you want sacrificed by that project. That's what zoning allows you to do. You get to decide where in the community the harm is going to take place. Essentially, that means you are left as a community deciding which neighbors you like the least. Who do you like the least? And that's where you get to zone the problem. However, even in the case of the pipeline, that doesn't really matter. Even if you tried that, even if you had some people that you didn't like in this community, say, all right, we're just going to zone the pipeline over there. Williams is on record in the paper as saying, we will try to respect zoning, but we don't have to. They don't have to respect local zoning laws under the existing structure of law because of the federal preemptive step. It's also where eminent domain comes in under federal preemption. Second side of the box. That says property rights. You're going to hear that if Williams or whoever gets all the leases they need, there's nothing you as a community can do about it because of their property rights. Can't stop it. They've got the leases, whatever it is they need, so you can't stop it because you can't infringe on the people's property rights with lease, or Williams' property rights to access that lease. The problem with this is that we restrict people's property rights all the time in our communities, if and when their use of that property would violate other people's property rights and violate other people's ability to enjoy their own property. So we put in place things like setbacks or berms around septic systems, or a lot of communities have restrictions on burning things like old tires in their backyard. Or we place restrictions on what you can dump into the stream, and that stream is going to be running through somebody else's property. We restrict property rights all the time if the way that somebody is going to use their property is going to violate somebody else's property rights. So it's definitely a misnomer and it's misleading to say you can't stop it because of property rights. We do restrict that in communities when somebody is going to violate somebody else's rights by the way that they use their own property. Third side of the box here. This says corporate rights. And I put rights in quotation marks because what's a corporation? Corporation is wealth on paper. Corporation is a chartered entity. Corporation doesn't exist unless it's given a charter by the state legislature that it is chartered within. Corporations themselves are not that. They're just people that are getting together to engage in an activity and they're given a charter to do so. I work for a corporation, most of us do. However, corporations don't exist without the permission of the legislature of the state that they were chartered within. You can look through the Constitution all day long, the federal U.S. Constitution. You can look through it. You will never see the word corporation in there anywhere. And yet, corporations have been found, at this point, by the U.S. Supreme Court to hold constitutional Bill of Rights protections that were originally intended just for natural persons like those of us in this room. Corporations now have First Amendment rights to free speech. They have Fourth Amendment rights to be free from unreasonable searches and seizures. They have Fifth Amendment rights to due process and to be free from governmental takings of their property. They have Sixth Amendment rights to face their accusers in court. They have 14th Amendment rights to equal protection of the law. They have Commerce Clause protections under the Constitution. They have Contracts Clause protections under the Constitution. All this may sound somewhat academic and not that interesting until you see how corporations are able to use these rights against your community. Because essentially what they mean in shorthand is that they allow 7 people on a corporate board of directors headquartered in some other state far from here to actually wield more authority in your community than a majority of people who live there. A couple quick examples on how this works. Again, I could go through these examples all night, but it's very depressing. But it's very important to understand how corporations, with the wealth and the lobbyists and the lawyers that they have behind them, can actually use these rights against what a majority of people in your community may want. So the Fifth Amendment, one of the clauses of the Fifth Amendment to the Constitution, is the right to be free from governmental takings of your property without just compensation. You might have heard some of this in the eminent domain conversations around the pipeline. You're free from governmental takings of your property without just compensation. If you, in Martic Township or wherever you may live, try to stop the pipeline from coming through, you could be on the other end of a lawsuit from the corporation that claims that you have violated their Fifth Amendment takings rights. And what that might look like is they could say, fine, you don't want us to put the pipeline through here? We've got the leases, we've got eminent domain, we've got everything we need. So by you not letting us put the pipeline through, even though we're all permitted and leased up, that's actually taking our property from us, taking our property right from us. And so, if you're not going to allow us to do that, that's a takings of our property, and that we then have the right to be compensated for the value of the gas that we would have otherwise moved through that pipeline. You've taken that from us, so now you have to compensate us, as Martic Township or may be, for the value of the gas that we would have moved, because you've taken it from us. That's one way they can do it. Another lawsuit that they can do would be under the 14th Amendment, equal protection. 14th Amendment was passed after the Civil War to apply the law equally to all classes of people, make sure that African Americans were protected as whites were after the Civil War. Corporations could now say, and they do in other communities, they say, fine, if you don't want to let us come in here, you are violating our equal protection rights because you are treating us, a corporation, differently than you're treating other people in your community. You are discriminating against us and denying us equal protection of the law because we have rights as persons under the 14th Amendment. It's another way they get to use these. Happens quite frequently, and what it means is that, again, a small number of people on a corporate board can use these constitutional rights to override what a majority of people in your community may want to see or not see. Last side of the box. It's what we call around the office as the regulatory fallacy. Because it appears to be our way out. What do we do when we heard about pipeline or any other harm that you might be concerned about in your community? Usually the first thing you do is you call your supervisors or maybe your state rep. And what's everybody tell you to do? Come out to the hearing. We're glad that you're concerned about the issue involved. It's great. There's going to be a hearing where everybody can come out and you can air out your concerns. We want to hear what you have to say. You might also call FERC or the DEP, or whoever the relevant permitting agency is. And you say to them, you know, we've got some real concerns, environmental concerns, community concerns, property value concerns, whatever it may be. We've got a bunch of concerns about this proposed project. And the friendly person at the regulatory agency on the other end of the line is usually like, we're glad that you're getting involved. We like to see community involvement. We want to hear your concerns. Please, we're going to have a hearing. Come on out. Come out to the hearing. We're going to listen to what you have to say. We're going to hear you. You might even call the corporation. Call Williams or whoever the relevant corporation is. And you'll usually get a very friendly PR person on the other end of the line. And that PR person will say things like, we appreciate your concerns. We're glad you're getting involved. We understand that, you know, the community does have some things that, you know, are concerned about with this, and we want to be good corporate neighbors. And so there's going to be a hearing. We're going to have some representatives there. You know, you can come on out and you can share your concerns with us so that we can come to an agreement together. Everybody tells you to come out to the hearing. That's where you're going to get your concerns heard, is where you're going to get to air everything out. What happens at the end of the hearing? We used to stage this with communities after we started doing the work that we're now doing, which is communities would actually go out to these hearings, and they would put it to the DEP representatives or whoever the relevant permitting agency was, and they would say, is anything that we actually say here tonight going to have any effect on whether or not the permit for the activity is issued? Is anything we say going to actually have an effect on whether this harmful activity comes into our community? And you can imagine the back and forth, there was a lot of hedging, it was good, you know, lots of different conversation. But if they kept putting the question to the representatives, the answer was always no. Nothing that you say here tonight is actually going to have an effect on whether or not the permit is issued. Because regulatory agencies don't have discretion. Again, if it's administratively complete, I's dotted, T's crossed, everything is filled in, the permit has to issue. Has to issue. That's why they're called hearings. They hear you, but it doesn't actually have any effect on whether or not the activity is given the permit. It's also why it's called public comment. I'm not saying do or don't do public comment. There's definitely reasons to do it, just getting your concerns on record. There's also a reason that it's called public comment, is that it doesn't have to affect the outcome of whether or not the permit is issued. It's public comment. It doesn't have to have an effect on whether it's issued. The very act of engaging with regulatory agencies in the first place assumes you're already on the defensive. That's why they're called regulatory agencies. They regulate harm. They issue permits to allow legal, allowable levels of harm, and the best bet that you can get working through the regulatory system is to try to regulate the rate or flow of harm in association with the activity you don't want. It's assuming you're on the defensive and that your best bet is to try to regulate the harm. That's why they're called regulatory agencies. They regulate. Once in a while, You'll hear the stories, they're probably floating around on the internet. I've seen a few about pipelines where this community or that community stopped the pipeline or whatever the activity. Once in a while, you appear to get a win working through the regulatory system. And that news spreads like wildfire. This is how a community won. This is where we had a regulatory win, where FERC finally listened, or the DEP finally listened, or whoever it was. This is how you win. Somebody that in the community we were working with one time called that random positive reinforcement. Random positive reinforcement, where there's the illusion that the regulatory system and that agency actually work on behalf of the community. But what a win looks like in the regulatory system means that at best you delayed it, or you made it so difficult for the corporation that they just moved the project elsewhere. It wasn't actually about democratically deciding whether or not you wanted the project to come in. It wasn't about saying yes or no as a community. It wasn't about saying these are the merits, this is why it's bad, and this is why we don't want it. It had everything to do with making life difficult for that corporation through the regulatory agency and hoping that you were able to make it difficult enough for them to want to go somewhere else. And everybody puts their lives on hold for years. I've seen it on many, many issues. And you hold bake sales to raise money. And you haven't seen your kids in many weeks because you're always running back and forth to hearings and different meetings. And you're going to Harrisburg or DC or wherever it may be for rallies or protests. And your back hurts and you're not sleeping very well. And you know your employer is getting concerned because you're using the copy machine for whatever you need for propaganda in your community. And at the end of it all, even if you get that win, you do everything right, and you hire the scientists and the lawyers and the lobbyists, and you've got some resources most communities don't, and at best you delay it or you force them to go somewhere else, it doesn't actually make it any easier for you to win the next time. It doesn't make it any easier. And it didn't actually stop it. Because even if you push the project somewhere else this time, they can reapply to come back in 30 days, 60 days, 6 months, whatever it may be. You didn't actually change the structure and make it easier for you to stop it. And so if they try to come back again, or maybe it's a completely different issue, maybe next time it's sludge, or maybe it's some harm we haven't even heard of before, you have to re-up, get the community groups back together again, educate yourselves, educate all your neighbors, come out to meetings like these, which I'm sure people are sick of hearing me already, and you have to do it all over again, and it never makes it any easier if you actually stop the thing that you don't want. There's a lesson that we had to learn the hard way as an organization and watching communities get harmed. And it's something that I still see play out, not just in Pennsylvania, but across the country every day. That's why we call it the regulatory fallacy. It's meant to give you the illusion that it's going to actually get you what you want, but in the end, at best, through the regulatory system, you're going to try to minimize the harm. You're going to try to get the best permit that you can. It's not about saying no, it's about minimizing the harm associated with the activity, regulating the harm. So, as we learned all this, and we explained it to ourselves, and we explained it to some of the communities we were working with, these farmers took a look at this box and they said, I'm not going to repeat their language because we're in a church, but they said, if what you're saying is true, if that's actually correct, that's baloney, number one. And number two, we would be foolish to continue banging around inside that box, hoping for a solution, hoping for a remedy from a system that wasn't written by us, that wasn't actually intended to protect us, and that wasn't intended to give us the remedies that we want in the first place. It was written by somebody else about 100, 150 years ago. So why would we continue to bang around inside of that box, hoping for a different outcome this time? That's all it is at that point, is just hoping for a different outcome, despite all this mountain of evidence to the contrary. So what they asked us to do at that point, they said, we ain't going to work in that box anymore. We'd like to do something different. And we would like you, meaning us, to begin drafting local laws with us, because we think that's where the change needs to start first, because we're the ones that are most affected by the decisions here. And we would like you to base them on our rights, our fundamental rights to govern our community, the right to local self-government. We haven't heard it much in Pennsylvania lately, but it's not a crazy out there concept. It was in the first couple of Pennsylvania constitutions. It's still in some other state constitutions. The right to local self-government, that the people who are most affected by decisions get to be the ones that actually make those decisions, not somebody else in Oklahoma. And they said we want it to be based on a right to self-government, on a right to clean air and clean water, And we want to be able to then prohibit activities which would violate our rights. So that's what we began doing with them. We actually began drafting ordinances in the early 2000s with communities that said we have a right to govern ourselves, we have fundamental rights to clean air and clean water, we have the right to be the ones that determine the future of our communities, and we're going to then prohibit activities that would violate those rights. Since then, over 100 communities in Pennsylvania have passed some version of these rights-based ordinances prohibiting activities like factory farms, sewage sludge spreading, toxic waste incinerators, the injection of toxic sludge into the ground, corporate water withdrawals, fracking, lots of different activities that communities have passed these rights-based ordinances prohibiting. There's over 150 communities across the country that have passed a version of these ordinances now as well, banning the activities that they felt were harmful. These ordinances come with some risks. You might get sued if you try to make a stand against a corporation or against the state or federal government that has legalized these activities. But the question at that point that the rights-based ordinances provoke is who has more rights here? Who has more say? Is the majority of us that live here and work here and raise our families here, are we the ones that actually get to decide? Or is it 7 people on a corporate board somewhere else whose only interest is in profit from this project and the benefits of this project aren't even staying local within our community? Who's got the say here? Right now when we go to court to argue through the regulatory stuff, we're arguing about parts per million, we're arguing about pipeline diameter, we're arguing about setbacks, we're arguing about routes, we're arguing about property values and all this other stuff. The rights-based stuff shift that, and they actually get out of that box and they create a new box that's about rights and who decides and who governs within the communities, so that they can actually have the fundamental conversation they want to have. As mentioned, that could invite a lawsuit. And there's currently 3 active lawsuits with communities that we have relationships with across the United States. There's currently one in federal court in New Mexico, one in state court in Colorado, and one in state court in Ohio. I don't want to downplay or minimize the negative effects of what a lawsuit could mean for a small community. Most rural communities that I work with don't have a lot of money, and having a lawsuit come in from a major pipeline corporation or anybody else can be a scary thing. I get it, and I understand it. But essentially, from our perspective, and what we usually leave communities with, is 3 options. You essentially got 3 choices. You can do nothing, and you can get the pipeline or whatever it is that you're concerned about. You can try to work through the regulatory system and do your best to try to either get it routed somewhere else or get some concessions or make sure they put enough topsoil back on or whatever it is may be that you're trying to get. It's still assuming you're going to get it, or if not you, that some other community will get it. Or you can step outside and do the 3rd option, which is asserting and protecting your rights, the fundamental rights that we all have just by virtue of living within our communities. A couple of quick pointers on this that I want to mention, and I'll open it up to Q&A. A lot of times people don't like it when I defend their supervisors. Usually by the time people get on the phone with me or invite me in, they already are not sure where their supervisors stand, or they might already be frustrated with them. But your supervisors find themselves in a tough spot. And I'm sympathetic to it, because they've taken an oath of office that asks them or requires them to do 2 things. The first thing is to uphold state and federal law. The second thing is to uphold with fidelity the duties of their office, which include protecting the health and safety of the community that elected them. So the number one thing that I hear from supervisors in Pennsylvania is, my hands are tied. Because how can I uphold state and federal law which legalizes and permits an activity which is going to harm the health and safety of my community on the other hand? How can I do both? How can I uphold state and federal law while protecting my community from the activity that is harmful? Their hands are tied, they really are. Usually the first thing the supervisors then do is they go to their solicitor and they say, what can we do here? Solicitor, the township lawyer. What is it that we're allowed to do here? And generally, the solicitor says, nothing. This is a matter of federal concern, it's not a matter of local concern. And if you try to take action on this, you do risk liability. You risk getting the township sued. That is a real risk. we have to remember is that the solicitor, doesn't matter whether he or she is a really good person, they don't work for the township residents. They're not concerned with your health and safety. The solicitor's client is the township corporation, the municipal corporation of Martic Township. And the solicitor's job is to protect that corporation from liability. So his advice, or her advice, that he's giving to the supervisors is based on keeping the township from having liability, the municipal corporation. So he takes a look at this structure, and he says this is clearly a federal matter, and so if you actually try to take action on this locally, you do put the township in the crosshairs of a lawsuit. So his advice generally to the supervisors is don't do it because that could put the municipal corporation in the crosshairs of a lawsuit. What folks that I work with often say is, well, that's great, and we're glad that the solicitor has issued his or her opinion, but they are not elected. Their job is to interpret the law. Their job is not to govern. The supervisors are the ones that govern, and we elected the supervisors to actually protect our health and safety. For the communities that we work with that have passed these ordinances, they have said and they've decided that their health and safety and their fundamental rights are more important to them than the threat of a lawsuit from a corporation. It's not an easy choice, and it's not mine to make or advise folks on. Lawsuits can be a scary thing, and they can carry with them real financial penalties, for the township, whoever it may be. But the question really, at the end of the day, is what are your rights worth? And is the threat of a lawsuit from a corporation more important or more persuasive to you than to keep you from asserting your rights and standing up? And the other question is, can you be okay with a system of law that currently right now denies you the authority to say no to harmful projects? Can you live with it? Are you okay with a system that currently denies you the authority and the right to say no to things that are harming you and your family and the people you live near? It's a hard question. This work is not just local. In other communities in other states, it's now moving to the state level. It's also beginning to do that in Pennsylvania. There was a constitutional amendment that was ran in, was trying to get run in Colorado this year about actually legalizing the right to local self-government. The work is really about, at this point, trying to take all the local energy, folks like in this room, and actually begin to try to change that structure from one that is currently denying our community's rights to one that would actually secure and protect the community's rights. Because the fundamental question is, what do we have governments for if we can't actually use our governments to secure and to protect our rights? The Declaration of Independence is very basic, very fundamental stuff. We institute governments to secure and to protect our rights. That's why we have them. It would be silly of us to create governments that would deny us our rights. And so, if we find ourselves in a system where state or federal levels of government right now are denying our communities their rights, then the communities we're working with feel like it's actually the duty of the local communities then to begin to take their rights back and to protect and to secure them. A lot of folks often wonder about the lawsuits, what's going to happen. I want to give two quick examples and then I'm done, I'll open it up for Q&A. Folks wonder how these are enforced. Have they worked? Have they stopped things? The answer is yes. In the over 150 communities that have passed these things, the activities that they prohibited in the Bills of Rights have not taken place within the communities that passed them. The activities have not gone in. They've been applied to, so far, energy infrastructure projects in places like New Hampshire and Maine, water withdrawals, factory farms, all the things that I mentioned. The activity has not gone in. One example in Pennsylvania of how something like this might play out happened in 2006. It was a small community, Packer Township in Carbon County, was concerned about sludge coming in, and they passed a community bill of rights prohibiting the sludge. In 2005, the Pennsylvania legislature passed a law called ACRE, which actually privatized the Attorney General on behalf of agribusiness corporations to sue communities to overturn ordinances if their ordinances got in the way of the sludge or agribusiness corporations. So 2006, Packer Township passes a community bill of rights banning the spreading of sludge within the township. They got sued not by the sludge corporation. They got sued by their own Attorney General, Tom Corbett at that time, who that community had just elected. They had just elected their own Attorney General, who then turned around and sued the folks at Packer Township on behalf of the agribusiness corporation. Makes the relationship much clearer between here and here at that point. where all these folks have to do, the agribusiness corporation, is pick up the phone, say, hey, Mr. Corbett, there is an out-of-control community in Carbon County that is passing crazy local ordinances, not letting us spread harmful sludge in their community. We need you to do something about this. To which the Attorney General then files a lawsuit against the corporate, or against the community. That was tied up in litigation for 6 years. The lawsuit was put on hold while Mr. Corbett was running for governor. He didn't want the PR associated with that lawsuit while he was running. After he got elected, they picked it back up. In 2012, the folks that originally wanted to spread sludge in the township no longer wanted to, and the case was dropped. So from 2006 to 2012, this was binding law on the books that prohibited the activity within the community. There was no sludge spread between 2006 and 2012. We were with that community the entire time during the litigation, and the lawsuit was dropped. One other quick example I want to mention, State College, Pennsylvania has a community bill of rights on the books that bans hydraulic fracturing as well as related infrastructure like pipelines. Last year, Penn State wanted to convert its coal-fired power plant over to gas-fired power plant. And they wanted to run a pipeline over to that coal-fired plant to convert it over to gas. They didn't want to run the pipeline through Penn State University's property. They wanted to run it instead down a right-of-way, down a residential street. Community, as you might imagine, as you folks are facing, was very concerned about the pipeline, safety reasons, a lot of other things, not least of which the fact that they had a law on the books that actually prohibited the thing. No pipelines, like at least 12 inches, which is what this pipeline was, could be put through the borough. So the community group said to Penn State and Columbia Gas, who was the gas corporation, said, look, we're glad you want to do this project, but you can't because we have a local law on the books that actually prohibits this new pipeline from going through the residential area, so you're going to have to take it elsewhere. Of course, the response from Penn State and Columbia was, that's too bad, you know, we're excited that you folks made your voices heard, we're excited you passed this cute little local law, but clearly it's unenforceable. Because this is a state and a federal matter. We've already got the permits and we've got the right-of-way area lined up and everything's on our side. And so, we're gonna talk with you. We'll try to, give you some concessions and, we'll assuage your concerns. But this isn't a matter of local concern. And so, your local law is pretty much unenforceable. So this brought out this series of back and forth meetings at Borough Council. 400 or 500 people coming out to these meetings. And the community group said, no, actually, it is a law and it is enforceable. And you, as corporations, don't have the authority to decide which laws you want to follow and which laws you don't want to follow. This is actually our law, and we passed it, and it's based on our rights, and we intend to assert and continue to protect our rights. To which Columbia and Penn State said, well, again, we're sorry, we're just going to have a court come in and validate this thing, and then we're going to proceed with our project. Because clearly this is unenforceable. You can't challenge this. This is a state or federal matter. It's not local. You can't do it. To which the community group responded again and said, no, actually we can, because you folks don't have the authority to violate our rights. The courts don't have the authority to violate our rights. And so, even if the courts say somehow that you can put this pipeline in, which we don't think they will, but even if they do, it doesn't matter. The pipeline is not coming into our community. It's not coming down the residential streets. It's dangerous, it's going to dump our property values, and it's not coming here. Regardless of what you think the courts are going to say. And if you still try to do it, we will stand in the streets and not let you do it, because at that point it will be up to us to assert and protect our rights if we need to, and we will do it, and we will enforce our local law. We will enforce it. It's ours, and these are our rights. And they forced Columbia and Penn State to back down. They did not put the pipeline through the community. So that's a couple of ways that this stuff can play out. It gets very real. I'm not going to sugarcoat anything and say that this is a panacea or it's an easy way out. I will say that there are communities passing them. They're actually taking on what they see as an unjust and illegitimate structure of law. They are stopping the harmful projects associated with it, but it does come with concerns, such as a lawsuit. And it's up to the community to decide whether that's a concern you can live with or not at that point. For communities that we work with that do pass these bills of rights, we do offer pro bono legal services in the defense of the ordinances if they're challenged in court by a corporation or a governmental entity. So if the community does get sued, we do offer free legal services. We ask for things like travel and filing fees and stuff like that, but we offer free defense of the ordinances if they are challenged in court. So, on that note, I want to turn it over now to Q&A. We're almost getting up to 8. Mark? Yeah. I'm going to turn it over to Mark for a minute, but I think we're going to get to Q&A.